Hello students, welcome to Legacy IAS Academy. Today we are going to discuss about the recently passed Digital Services Act by the European Union Parliament. We are going to discuss how this act aims to regulate the internet and internet related companies and as well as the search engines like Google, Yahoo as well as Microsoft Bing. So first of all, if you look into the context in which we are discussing this particular issue. So recently the European Parliament as well as the European Union member states have collectively announced that they have reached a political agreement on the Digital Services Act, that is called as DSA in the short. It is going to be or believed to be a very landmark legislation as far as the control over the internet companies in the matters related to the spread of disinformation or illegal and harmful content is concerned. The main aim with which this act has been passed is to provide better protection for the internet users as well as protection of their fundamental rights as far as the right to information, access to information as well as spread to information is concerned. The proposed act is believed to be work later in conjunction with another act that has been passed last month, that was the European Union's Digital Markets Act. Now, if you look at the background of this particular act, so first time the act was proposed by the European Union Commission, that is Antitrust Commission, in the month of December 2020. As per the definition given regarding to the digital services, European Union defines it as a set of common rules on intermediaries' obligations and accountability across the single market. Here, single market refers to the market of European Union, and they actually want to enforce or bring all the intermediary software intermediary companies, internet intermediary companies, so that they will have a common set of obligations and accountability, and thus it will be much easier to enforce these rules and regulations across all the European Union member states. As discussed before, it is going to be adopted by European Union Parliament in the next few months, and it is believed that once it is adopted with the Parliament, it will apply from 15 months after the date of adoption or from the January 1st, 2024, whichever is later. Now, some salient features of DSA, salient points about DSA. So first of all, it aims at moderating the user content. Earlier, the companies or the organizations like YouTube, Facebook, Instagram, all these companies were actually having a main say or having a different guidelines that how will moderate the user content, whether it is a violent content or whether it is some illegal content or whether it is some content that is that can cause a disturbance in the public morality and health. So in these issues, the YouTube, Facebook, all these companies were sole we can say deciding authority in that. However, now this DSA will publish specific guidelines that how these content have to be moderated out. Second, it also talked about the specific rules and obligations, especially if content is deemed to be of abusive or illegal characteristics. And third, it is believed that it will bring into ambit a large category of online services ranging from website having very simple websites to the internet infrastructure services as well as other online platforms. So it is a wide encompassing act that will have a specific rules and obligations to tackle the abusive and illegal content as well as specific guidelines that how the moderation of the user content has to be achieved. So obviously the question comes that which companies or which platforms are the one on which DSA will be applicable. So European Union has clearly said that all those online platforms which are having more than 45 million monthly active users will come under the ambit of this act. Now under this ambit, which kind of companies will come under? So all the companies that provide internet access to the users. Apart from that, the companies that is also involved in the domain name registration activities, and also the companies that are actually doing hosting services. Hosting services, it can be hosting of cloud hosting or it can be hosting of simple websites. So all these three kind of companies will come under the ambit of this particular act. Apart from this, there is also a specific guidelines that is given that companies that is deemed as VLOPs. VLOP represented very large online platforms as well as VLOSEs, that is very large online search engines. For example, you have very large online platforms can be Facebook, very large online search engines can be Google. So such kind of companies will face more stringent requirement as far as their content and the publication of content is concerned. Now, what about the enforcement of this act? So as per this act, a special body will be set up that will be called as European Board for Digital Services, and this body along with the national government of each of the member state of European Union together will be the one who will be responsible for enforcement of this act. Apart from that, European Union Commission will also play a very important role in case of VLOPs and VLOSCs, as we discussed before, whenever the enhanced supervision and enforcement are to be considered. Third, this law also says that in case of breach of this act or breach of the law, the penalty will be very, very high, and it can be as high as 6% of the company's global annual turnover. So this will be a very humongous amount as far as the companies, big companies like Google, Facebook, Meta and all these companies are concerned. Now look at the salient points of this particular act. So first of all, they have outlined a new procedure for faster removal of illegal or harmful content. Before, there was no such timelines and when such harmful content can be removed, or what is the timeline within which the company or the online platform have to take the decisions. But now this has to be removed as fast as possible as per the guidelines given by the act. Second, they also have imposed a duty of care on seller. For example, we have a lot of companies, online platforms that are connecting the buyers and sellers. The best example of this we can understand from the example of Amazon. So what this Digital Services Act have said, that Amazon will have responsibility, and the sellers on the Amazon will have responsibility to ensure that all the information regarding a particular product which you are selling are clearly mentioned on the website, so that the buyer or user can take an informed decision that whether he or she want to buy this product or not. Then third, it also has said that there will be obligation for very large digital platforms and services to analyze systemic risks which they create, and they carry out risk reduction analysis. For large companies like Facebook and Google, this risk reduction analysis will have to be done on an annual basis. Then the next important point is that this act allows the independent weighted researchers to have access to public data from these particular platforms, so they can carry out research and publish the particular result for the benefit of humanity and humankind. Then it also aims to ban the dark patterns or misleading interfaces. So dark pattern or misleading interfaces refers to such information on the online platforms or on the internet which can mislead the user and trick them into taking such decisions which they would not have taken otherwise. It can be tricking them into buying some subscription or buying some products which they do not want to buy just by misleading interfaces. Third, it also has said that there should be no recommendation to user just on the basis of their profiling. That means recommended content based on the profiling of user profiling will be prohibited or banned as per this particular act. And here new crisis mechanism clause has been inserted as per this act. Now what is this new crisis mechanism clause? So this clause has been inserted taking into consideration the recent Russia-Ukraine war. Now under this new crisis mechanism clause, the Digital Services Act clearly mentions that the analysis of the impact or crisis on the online platforms will have to be analyzed, and on basis of this it has to be ensured that the fundamental rights of the users are not threatened. So that is something that has to be ensured even in crisis like situations, that every user has their fundamental rights intact. And this decision will be taken on the basis of a body that is called as National Digital Services Coordination. It will be an European Union wide bodies, and each country, European Union member country or European Union member nations can take separate decisions on the recommendation of this NDC. Then apart from this, the Act also have envisioned a stronger protection for the minors, where Digital Services Act clearly mentions that profiling of minors will be prohibited. Whatever information regarding minors are available, this information cannot be used to give them modified content or curated content, or give them some advertisement that the minors will be willing to buy. Then second, it also have ensured a transparency measures for online platforms on variety of issues, especially the online platform will have to be very transparent regarding the methodologies or algorithms which they are using for generating advertisements. As far as the subscription of any membership of any online platform is concerned, for example Prime membership, that should be cancelling of that such membership or subscription should be as easy as subscribing itself. So these are the some important points which this new act tries to bring for the first time. Now, what about the liability of social media platforms? So as per the Digital Services Act, if any user of any social media platform is involved in unlawful behavior, in that case social media platform will not be held liable. This protections comes under a clause that is called as safe harbor clause. The safe harbor clause basically says that for any unlawful behavior of users, the platform cannot be held liable. That is simple. However, there has been one catch. They have says that the social media platform, however, will become liable if the social media platforms are aware of the illegal acts of the user and still they fail to remove them. For example, we take publication of child pornography. So that is obviously illegal. So if social media platform is aware about such kind of publication and still have not removed them, then apart from the user, the platform will also become liable for penalties and legal proceedings. Third is, it also says that smaller platforms which remove any illegal content that detect will also not be liable under this particular act. Now let us try to talk about the India's law regarding the same. So first of all, India last year has passed a law and it has says that the social media companies will be liable if the company fails to carry out the due diligence procedure. And it also has now mandated that all the big companies, for example Meta or Google, they will have to appoint a chief compliance officer or CCO, and this chief compliance officer can be booked under the law if a tweet or any post that is actually seen as a violating the local laws is not removed within the stipulated period. So here the burden is on the chief compliance officer that he have to make sure that all the illegal posts or the post that is violating the local laws are removed within a given time frame. Apart from that, a third point that has been added in India's law is that a monthly compliance report has to be submitted by each of the online media platforms or social media platforms, so that the government can trace the originator of a message if need arises. However, this is the contentious matter, and on this the WhatsApp, the very popular this we can say a messaging app under Meta, they have challenged this decision of government in the Delhi High Court, where the matter is still pending. So we'll have to see how High Court treats this clause and whether it upholds this or passes this. So that is all about the Digital Services Act, and we also try to understand that how does this act is similar or dissimilar to the India's law regarding the similar provisions. That is all for today. Thank you very much.